Sorry, I'm going to do that again. Aboriginal and Torres Strait Islander people and the justice system. The effectiveness of culturally proficient sentencing. A presentation by Gillian Eshman. There have been many different approaches trialled to improve the relationship between Indigenous people and the criminal justice system in Australia. Some of these approaches have been directed at policing relationships, such as the introduction of Aboriginal community liaison programs with officers who are Aboriginal community members, bridging the cultural gap between the community and police. Other approaches have focused on the statutory system, including recognition of the need for culturally appropriate accommodation and supports. This presentation discusses examples of innovative sentence courts aimed at supporting the rehabilitation of Indigenous offenders. These processes are often touted as providing a more culturally appropriate and inclusive courtroom experience for offenders. For Indigenous people, as with non-Indigenous people, the most common court experience is a guilty plea and sentencing procedure. The sentencing process is critical because it provides an opportunity for the intervention and diversion of prisoners rather than the yo-yoing of recidivism. The need for intervention and diversion is important because since the 1991 Royal Commission into Aboriginal deaths in custody, the overrepresentation of Indigenous people in Australian prisons has worsened. In 1991, Indigenous people comprised of 14% of adult prisoners, while in 2012 the rate was 27%. Indigenous imprisonment rates have more than doubled from 1,234 per 100,000 people in the early 90s to 2,303 per 100,000 in 2010. This is compared with 169% of 169 per 100,000 for non-Indigenous people. Indigenous men are now overrepresented by a factor of 13.4, and Indigenous women are 16.5 times more likely than non-Indigenous women to be imprisoned. On this slide are some of the international conventions and rules that apply for this. Circle sentencing is a form of restorative justice. Circle sentencing is based upon the traditional practices conducted by Indigenous communities in Canada, where it was reintroduced in 1992 in the Yukon Territory before being adopted internationally in 1996. Circle sentencing involves the offender, local Aboriginal elders, and presiding judicial officers, prosecutors, offenders' lawyers, and the victims sitting in a circle in a community setting where the offence, the offender's background, and the impact upon the victim and the community are discussed. To be eligible for circle sentencing, the offender must either plead guilty or have been found guilty of the offence. The elders decides upon an appropriate penalty which is recommended to the judicial officer to either accept or reject. Circle sentencing is not a diversion from jail. Both community-based and custodial sentencing options may be considered by the elders. Indigenous sentencing courts have been championed by individual magistrates and Indigenous community members and are recognised as a legitimate forum for sentencing Indigenous offenders, with the enactment of legislation to validate the courts. New South Wales and South Australia have amended their Criminal Court Procedure and Sentencing Acts to formally recognise Indigenous sentencing court processes. Prior to this, the courts were operating under general sentencing provisions and certain practice directions which placed an obligation on the court to have a regard for the cultural impacts and the community submissions when sentencing an Aboriginal or Torres Strait Islander person. Indigenous sentencing courts operate in all Australian states and territories except Tasmania. These courts have been established according to the protocols and practices and can be distinguished from more informal practices that occur in remote areas where judicial officers are travelling to local community. The courts have both criminal justice aims, such as reducing recidivism, improving court appearance rates, and reducing the overrepresentation of Indigenous people in the criminal justice system, as well as focusing on community building aims and providing culturally appropriate processes, increase community participation, and contributing to reconciliation processes. Circle sentencing places the community sentencing court in a community setting in order to achieve the following goals: promoting healing for all affected parties, providing an opportunity for the offender to make amends, empowering victims, community members, families, and offenders by giving them a voice and a shared responsibility to find constructive resolutions, addressing the underlying causes of criminal behaviour, building a sense of community and its capacity for resolving conflict, and promoting the shared community values. The process is as much about the needs of the victim and the community as it is about addressing offending. It is about resolving problems, building stronger relationships, and preventing further offending from occurring. There are a number of circle sentencing currently happening, and on this is just a few of the main Indigenous courts that I will discuss today. Circle Sentencing Program New South Wales. In response to the recommendations of the Royal Commission, the New South Wales Aboriginal Justice Advisory Council put forward to the Standing Committee of Criminal Justice Systems Chief Executive Officers a proposal that circle sentencing be trialled in New South Wales. In 2000, the New South Wales Government introduced legislation aimed at establishing and running a circle sentencing intervention program. The objectives of the intervention program were: include members of Aboriginal communities in the sentencing process, increase the confidence of Aboriginal communities in the sentencing process, reduce barriers between Aboriginal communities and the courts, provide more appropriate sentencing options for Aboriginal offenders, provide effective support to victims of offences by Aboriginal offenders, provide for the greater participation of Aboriginal offenders and their victims in the sentencing process, increase the awareness of Aboriginal offenders in the consequences of their offences on their victims and the Aboriginal communities to which they belong, reduce recidivism in Aboriginal communities. The Koori Court, Victoria. The Koori Division of Victoria's Magistrate Court currently operates as a permanent court of the Magistrates Court under the Magistrates Court Koori Court Act 2002. The Act states that the Koori Court should be established with the objective of ensuring greater participation of the Aboriginal community in the sentencing process through the role played by Aboriginal elders. Section 4D, Parts 4 and 5 state that the Koori Court Division must exercise its jurisdiction with as little formality and technicality and with as much expedition as the requirements of this Act and the Sentencing Act 1991, and the proper consideration of the matters before the court permit. The Gallimbani Circle Sentencing Court, ACT. The Gallimbani Circle Sentencing Court is a specialist court within the ACT Magistrates Court and was introduced after a pilot program in 2004. The Gallimbani Circle Sentencing Court has 7 primary aims: involving Aboriginal and Torres Strait Islander people in the sentencing process, increasing the confidence of the community in the sentencing process, reducing barriers between the courts and Aboriginal and Torres Strait Islander communities, providing cultural relevant and effective sentencing options for Aboriginal and Torres Strait Islander offenders, providing support services that will assist the offenders to overcome his or her behaviour, providing support for victims of crimes and enhancing the rights and place of victims in the sentencing process, and reduce repeat offending in Aboriginal and Torres Strait Islander communities. Our evaluations of each of the 3 circle sentencing courts identified improvements in the relationships between courts and Aboriginal communities. However, this success has not impacted on the recorded data on recidivism. Recidivism is affected by many factors, of which sentencing is but one. It could be argued that the improved relationships and the diversion of offenders away from prison will have a generational impact on recidivism. I hope you enjoyed my presentation. Unfortunately, I've run out of time. If you have any questions, please post them on the page. Thank you.